Hi, this is the last of the 3 lectures on the U.S. Judicial branch. We continue our discussion on the U.S. Supreme Court. The ruling process for the court is that first the cases are put on the court's docket, and then briefs are submitted by both sides, and so-called amicus curiae briefs are filed, which are the friends of the court briefs, which are the opinion pieces submitted by third parties to inform the justices about various aspects of the issue at hand, as you would remember from the earlier part of this lecture. And then oral arguments are held, and both parties' lawyers come before the court and make their case orally. And then conference cases, in the conference, the justices get together and discuss the cases. They vote on them, and then they are assigned for writing their opinions. Then they turn around and write their opinions individually, then share it with the presiding justice, which doesn't have to be the chief justice. It could, every case has a different justice that presides over on the case. So that justice collects all the opinion positions from all 9 justices, or 8, not including himself, and then the decision is announced. The presiding justice also votes on the matter and provides an opinion paper as well. And whichever opinion wins, that becomes the court's overall position. However, when court announces its overall position, it also makes note of the dissenting justices' viewpoints as well. Court's rulings, they try to be consistent with precedents, which is the past court rulings, and the majority vote wins the decision, wins the case, as I mentioned. So 5 votes are needed, and 3 different types of opinions are issued: the majority opinion, the dissenting opinion or opinions, and concurring opinions. Concurring opinion is the opinion of those justices that explains the legal reasoning agrees with the majority's position, but for a different reason. So therefore, they explain why they agree with the majority opinion, and this is called concurring. One unique aspect of the U.S. Supreme Court is that it has the judicial review authority, which means that the U.S. Supreme Court does have the authority to interpret constitutionality of various actions of the U.S. Congress. That right is not a right given to the court by the U.S. Constitution. It is a right created by a past ruling of the Constitution. In 1803, the famous Marbury versus Madison case created the right of judicial review for the U.S. Supreme Court. So a good discussion point or thinking point for us here is whether the constitutional review or judicial review compromise or further the democratic credentials in a country. On one aspect, one would consider it as a democratic instrument because it highlights the supremacy of law by placing judicial branch over the other 2 branches as the sole authority that has this type of a power. But on the other side, some legal observers argue that it's also an undemocratic institution or concept, because justices in the U.S. Supreme Court are not elected officials. They are appointed, politically appointed, and also they cannot be removed from office because of incompetence, so they're not accountable to the public. And these individuals, as much as we trust in them and as fascinating careers as they might have, they are at the top of their legal careers and very highly reputable, highly respectable legal minds for all practical purposes. But nonetheless, there are 9 individuals who are not elected and who cannot be removed from office. So it's a bit of a too much of a power given to such an institution, according to the second view. The first view is that in terms of how the U.S. Supreme Court should issue its rulings, how it should handle its business, there are two competing viewpoints. One is that the Supreme Court should not create or issue rulings that have the effect of creating laws. And this approach is called judicial restraint. So, for example, I mentioned that the Marbury versus Madison case in 1803 created the right to judicial review for the Supreme Court. That, in effect, has become a legislative work for the court, and this would be the opposite of judicial restraint. On the other side, some other observers argue that there's nothing wrong with the Supreme Court taking an active role in policy making, including revising the U.S. Constitution that it interprets, simply because Constitution is a living, or should be a living, institution. And as time passes, the society changes and its needs change, and as a result, the Supreme Court should change as well, and should take a proactive role in reviewing the Constitution for various updates. And this approach is called judicial activism. So some examples of judicial activism would be the famous 1973 ruling, Roe versus Wade, which created abortion as a women's right on the grounds that it's a matter of privacy for women as it impacts their bodies. And also a 2015 ruling of Bergefell versus Hodges, which recognized gay marriage as a constitutional right protected by not one but two clauses of the U.S. Constitution, the Equal Protection Clause and the Due Process Clauses of the Constitution. So when we look at the U.S. Supreme Court's history, we see that there are a number of highly consequential rulings in the court's background. Here in this lecture, I included only 5 of them that are considered to be the landmark cases that led to some fundamental shifts in the U.S. society. First of those was a case here in Texas, actually, Johnson v. Texas, in which a citizen staged a protest in front of the Democratic Party convention, and he burned the U.S. flag as a part of his protest, and he found trouble for doing that, and he was charged with various crimes, as the flag represents the integrity and the honor of the society, etc., and it's considered to be an act against the state. But the U.S. Supreme Court, in its ruling, rejected this claim and said that as disagreeable and perhaps even despicable as it may be, flag burning is a form of political expression and therefore is a protected act protected by the First Amendment of the U.S. Constitution, which says that which gives the citizens both the freedoms of expression as well as political assembly and expression. A second very consequential court case was the Roe versus Wade 1973, which created abortion as a constitutional right for women, even though it also brought certain restrictions to it. It divided pregnancy into 3 equal terms, the court called trimesters, and said that it's an unrestrictable right for women to have abortions on the first trimester, and there are certain conditions on the second trimester, and no abortions on the third trimester, simply because the fetus resembles too much of an earlier phase of a human being, and therefore it constitutes some form of a murder to carry out an abortion at a later phase of pregnancy. The court in later years changed this trimester approach to a viability approach and said that if the pregnancy should be divided into two pieces instead of three, and in the first part the fetus is not viable, meaning if for whatever reason the fetus is taken out of the mother's womb, then he cannot remain alive on its own. So his organs and bodily functions haven't developed enough for it to survive without the mother. And in that phase of the pregnancy, the court said that it's an unrestrictable right of women to get abortions, but it is restrictable in the later phase where the fetus is viable outside the womb. I am including videos that explain these cases for you in these slides. Please make sure to check them out and get more specific details about these lawsuits, which are quite interesting and also very much relevant to all of our lives today. A third highly consequential court ruling is the Loving versus Virginia case, and in this case, a white gentleman married a mixed-race lady, African American and Native American mixed-race lady in the state of Virginia, and in the state of in Washington D.C. But they resided in Virginia. So when they came back to Virginia, the state of Virginia found them in violation of the state's ban on interracial marriage, and this was 1950s. So I'd like to remind everyone. And so they imprisoned them, but the case caught the attention of some civil libertarians. So they filed a lawsuit, and the case went up all the way to the U.S. Supreme Court. And after a long battle, the U.S. Supreme Court found the couple to be within their rights, and the court said that no state cannot recognize the legal actions of other states, and interracial marriage cannot be restricted this way. This couple was not in violation of any kind of a law. It's their constitutional right to marry with whomever they want. By the way, recently a movie was made out of this couple's struggle by the title Loving. So I suggest you check it out if you find an opportunity. It's a remarkable movie that reminds us of the struggle that they had to go through. A fourth case was the Miranda versus Arizona case. So for those who are familiar with true crime shows or or others, or movies perhaps, the cops say reading the person's Miranda rights, right? Reading his rights. This is the Supreme Court case that created that right. And so it says that the court said that when a person is arrested by a law enforcement officer, then the officer has to read his rights, which includes his name, the reason why he's arrested, and the fact that he does not have to say anything just because he's arrested. And if he chooses to say anything, then anything he says can be used against him in the court of law. So this was another interesting case that created that law for all of us. And the last case is the famous Citizens United case in 2010. And in this case, the Supreme Court issued one of its most controversial rulings in its history, and argued that corporations are individuals, and therefore they should have the freedom to donate as much money as they want to political campaigns.